welcome to the Mock Tribunal. Thank you all for coming here at the crack of dawn, actually to the marvellous facilities at Harbury Park, which I haven't enjoyed before. If you haven't, I'm sure you'll agree. Fantastic. Thank you to Helen for organising this as ever. We are now going to try and create, as best we can, a tribunal setting. This will involve witnesses, the cross-examination of witnesses, and obviously, as has been before, the marvellous Judge Kevin Charles. We are also delighted to have two, we must not call them wing members, we must call them members. So Jill and Nick, who have very kindly offered to stand in and assist. Obviously, any questions please keep to the end, because we are going to have this flowing as a proper tribunal. We are going to keep it as true to life as we possibly can, but afterwards we're more than happy to answer any questions that you might have. Please could you ensure that your mobile phones are off, and also if you don't know, the toilets are just out the back there, so please feel free to sort of quietly nip out if you are desperate. And emergency exits are that way. Just follow me if the alarm goes off. We're not planning anything. So I think that's all I need to say. Therefore, in the circumstances, I think we probably need to hand the court over to Judge Kevin Charles.
Morning, gentlemen.
Good morning, sir.
My name's Employment Judge Charles, and I'm assisted this morning by members Nick Tinsley to my left and Mrs. Jill Locke to my right. Mr. Ross, you appear on behalf of the claimant, is
That's
that
correct.
Right. And Mr. Deere, you appear on behalf of the respondent.
Yes, sir, that's correct.
Okay. And just to clarify, I've got with me a copy of a paginated bundle of documents. I think that's been prepared by the respondent.
Yes, sir.
I also have witness statements. I've got a witness statement of the claimant, Mr. Gideon Burnish.
Yes, sir.
Witness statement of respondent John Biggott and Sarah Miles. And just to commence, Mr. Ross, I understand that there is an application for a witness order. That has been granted by the tribunal. Can you tell us whether or not the witness is actually present?
So she has not been able to attend as yet. I understand that there's an issue with trains this morning, previous to her being here at present, but we do understand that she will be here later on in the day. If it's at all possible, we would like her to give her evidence slightly later than normal, in the normal order of things.
Okay, and you will keep the tribunal up to date, won't you, in terms of how?
Absolutely, so as soon as she arrives, I will let you know.
Okay, thank you. Let's just clarify the issues in dispute, gentlemen, so that we all know where we stand before we start. As I understand it, we have a claim of direct discrimination.
Yes, sir.
That is on the basis of sexual orientation, is that right?
That's correct, sir.
We also have a claim of victimisation.
There's an application to amend the ET1 to include a claim of victimisation, sir, but it is an issue that will be considered today.
Okay. We have an issue of a reasonable steps defence. Is that right, Mr. Deere?
That is correct, sir, yes.
And just help me, can you just give me the basis of that?
The first respondent, in Smart Limited, have set out in their response in defence to the claim that they have taken all reasonable steps to prevent such an incident as that alleged by the claimant. Specifically, they provided training to those members of the recruiting panel and team that interviewed the claimant in relation to equal opportunities and discrimination. And therefore, they are arguing that if the alleged incidents took place, that those were the acts of the second respondent alone.
So the first respondent is basically seeking to wash its hands of any liability and to pass it all on to the second respondent. That's it in a nutshell, isn't it, Mr. Deere?
They are saying that ultimately it would be the responsibility of the individual, although they maintain the defence alongside the second respondent, that the allegations are not made out and the claim is not made out.
Okay, well, we'll hear what Mr. Ross has to say about that in due course when we come to submissions. And I understand there's one other point and that's as far as the ACAS early conciliation procedure is concerned. Is that right?
Yes, sir, as I understand it, it's set out in the ET3 on part of the respondent that there is an issue with the early conciliation certificate, and in particular that the name of the parties is incorrect. From the claimant's point of view, the rules on this are quite clear. Rule 12.2a of the Employment Tribunal rules sets out that unless the judge considers that the claimant made a minor error in relation to name or address, it wouldn't be in the interests of justice to reject the claim. That, and also taking into account the leading case in this area, MIST and Derby Community Health Services, if there is a discrepancy between the name of a prospective respondent on an early conciliation certificate and the name given on an ET1, that should not ordinarily prevent a tribunal from accepting that claim, and that's what the claimant would ask of you today.
I understand, Mr. Ross. Can I just say to both representatives, I know you're both extremely experienced, but given that we're fortunate to be in this lovely cathedral type building, if you could keep your voices up, I know there's lots of space to cover. Well, let's move to the evidence. Mr. Ross, this is your claim of discrimination, and therefore it falls to you to go first and to call your evidence.
So, do you wish to consider the application to amend first?
No, I'm going to consider that at the end, and I'll hear submissions at the end. What I want to do, Mr. Ross, is to get on with the evidence.
Thank you, sir.
How would you like to take the oath?
Affirm. I sincerely and solemnly affirm that the evidence I shall give will be the whole truth and nothing but the truth.
Thank you. That's it.
Mr. Burnish, in the pack in front of you, you'll find a copy of your witness statement. Can you get that out?
Yes.
And can I confirm that that is your name and address on the first page of the witness statement?
Confirmed.
And that's your signature on the last page?
Yes.
And have you read this statement recently?
I have.
And is it true to the best of your belief and knowledge?
It is.
Many thanks.
Mr. Ross, I'd like the witness to read the witness statement, please. I know it's the normal procedure to take statements as read. However, I think particularly in discrimination claims, it's important to hear what the witness has to say. So, Mr. Burnish, if you could read that witness statement, please. If you could just take your time. There's water on the witness table, and if you could just take us through that nice and slowly, so that my members and I can absorb your evidence.
Okay. So I'm 34 years old and I've worked in customer service ever since leaving school at 18, working my way up from customer service advisor to customer service manager in my last job. In April this year, I saw an advert for a customer service manager at Clean and Smart. I was very interested as it was much closer to home for me and was a setup. The pay and rewards were much better than my current role, and I felt there was the ability to progress within the organisation. I had also heard a lot about the organisation because I have a friend who works there. I submitted my application to the recruiters and was very pleased to get an interview. I'd done all the right things, and I'd sent in a cover letter and tailored my CV to make sure it was completely relevant to the job. On the day of the interview, I made sure that I put on my best suit and shined my shoes very brightly. The interview went really well. The director who interviewed me, Sarah, was very kind and very interested in my previous experience. She said that she thought that I sounded perfect for the job, but wanted me to come back in for a second interview later in the week with another senior director, who I would also deal with on a regular basis. I was happy to do so. However, this second interview did not go so well. Unlike the friendliness of the first interview, the second interview was much more stilted. I got the impression that the person interviewing me, John Biggott, had taken an instant dislike to me, and I could not understand why. He asked quite a few questions about my personal life and kept asking me if I had a girlfriend. I told him I did not. When I got up to leave the interview, Mr. Bigot could hardly bring himself to shake my hand, as if I had some sort of plague, and mumbled that the recruitment agency would be in touch. Indeed they were. Within minutes of me getting home, they phoned with the bad news that I had not been successful. I was devastated, as I was really excited about the job. I contacted my friend Charlie, who worked at Clean and Smart, and asked her if she had heard anything, and she was a bit sheepish. She said that John Bigot had come straight down to see her and had demanded to know if I was gay. Apparently he had seen the gay pride bracelet that I had discreetly on my wrist, and it suddenly made sense as to why I had so many questions about whether I had a girlfriend or not. I don't have a boyfriend either, but frankly, I do not think that this was any of his business, as my sexuality is my own business, and I don't feel inclined to discuss it with any potential employer. I expect to be judged on my ability to do the job. I rang the recruitment company and asked them whether I did not get the job because I was gay. There was a hesitation before Katie answered the question, but she said she did not think so. I do not believe her and asked her to send me an email confirming exactly why I did not get the job. Her email to me says that the business felt I was not the right fit in personality, and that although I had the experience, it was important to get that right. About a week later, I was walking down the high street in Didcot, and Sarah, the first director who interviewed me, was coming the other way. She smiled and said how sorry she was I had decided not to take the job, and I explained that I had not been offered it. She looked very confused and said that she had been told that I had been offered the job and did not think it was enough money. I explained that this was rubbish. She looked really surprised. I decided to write to HR and express my concern that I did not get the job because I was gay. They wrote back and said that this had nothing to do with it. It was just felt that I would not be the right fit for one half of the business. The only reason I would not be the right fit was because I'm gay, and I don't think they should be allowed to make recruitment decisions based on their prejudices. My friend Charlie, who works there, obviously did not want to get involved because she might lose his job. I explained to her that if she loses her job, because she helped me bring a claim of discrimination, then this would be victimization. But she has a young family and did not want to take the risk. I was obviously disappointed but understand her position. I believe that the only reason I did not get that role was because I'm gay, and I have decided to take a stand because in the 21st century this should not be allowed to go on. I'm claiming the difference between my current package, which is £37,000 per annum, and also a company car, private healthcare and death in service, none of which I get in my current role. In addition, I have been very upset by how I've been treated and have undergone a number of counselling sessions which I have paid for privately. I therefore also claim injury to feelings. Because John Bigot telephoned my current employer once he found out that I was bringing this claim, I've also been told that the pay rise I was going to be receiving to £40,000 is no longer going to be offered to me because they do not think that I'm committed enough.
Mr. Burnish, thank you very much. Mr. Ross, do you have any further questions in chief to put to this?
No, sir, thank you.
In that case, Mr. Dirks, over to you for cross-examination.
Thank you, sir. Good morning, Mr. Burnish.
Good morning.
As you know, I represent the respondents in this matter, and what I'd like to do is just go through a few points in your witness statements and ask a few questions about them, if I may. I appreciate that your main grievance, as you set out in your application and in your witness statement, relates to the interview that took place with Mr. Bigot. But before we get to that point, I'd just like to clarify a few points in terms of background, if I may. So, before your application to my client, you were employed as a customer services manager at Big Co Limited.
This is incorrect.
In spite of the offer letter that you have in the bundles, Mr. Burnish. You say that
Can I refer to that?
Can you help us with a page number in the bundle, Mr. Dirks?
So, well, first we'll look in the paragraph 1 of the witness statement, and then page 26 in the bundle. So here we have a letter from a Louise Green. So further to your interview with Mr. B. Cheeseman, we are delighted to make you an offer of employment with Bigco Limited as a customer services manager.
I must have been confused when I gave the statement.
So you don't work for that company?
I do work for the company. Well, I work for Louise Green. Yes, I work for that company. But I'm not quite sure why there's a discrepancy.
I don't see the discrepancy myself, Mr. Burns. You say at paragraph 1, you employ as a customer services manager, and that letter sets out an offer to you for that role.
Yes, I'm definitely a customer services manager.
Okay, it's a relatively minor point, Mr. Burns, so I'll move on. So despite that being the same job title as your current role, you're of the view that the role on offer with my clients was a step up, a promotion, if you will, the next rung on your career ladder. Is that correct?
Yes.
Plus, this was a company that you wanted to work for. You'd heard good things about it from people who already worked there.
I'd heard that there was ability to progress in the organisation.
And is this information, you mentioned a friend that already works there, is this your friend Charlie, who you also mentioned in your witness statement?
Yes, it is.
And so I'm assuming I'm correct, could you confirm she said nothing in the past that put you off making the application?
Not that I believe.
No. So your application and the interviews that you attended were your opportunity, your chance to prove yourself to be the right person for the job.
I believe so, yes.
Can you just confirm you had never met either Sarah Miles or John Biggott before your interviews?
I had never met them.
So they knew nothing about you prior to the interviews, apart from obviously the information you set out in your application.
I don't believe they did.
Paragraph 7 of your witness statement, if I could just take you to that for a moment.
Yes.
You say, I expect to be judged on my ability to do the job.
Correct.
Is that the only criteria you expect an employer to consider as part of the recruitment process?
Well, I believe that this is one of the main criteria. It's about doing the job.
So, as you say, the main criteria, the principal point that you expect an employer to consider.
I didn't necessarily. I think it's one of the principal points.
But you've made the point, you have said in your witness statement, I expect to be judged on my ability to do the job.
But I think that's one of the principal points, but I haven't said that it was the principal point.
Okay, so you accept that there are other factors that the employer might take into consideration?
There's a possibility, it depends on the job. Each job has...
Well, for example, if I may, at paragraph 4 of your witness statement, you said before your first interview, the one that took place with Sarah Miles, I put on my best suit and shined my shoes very brightly.
As I said, that might be a minor point, that's not necessarily...
But as you say, you made the conscious effort to give yourself a smart appearance.
But that's something that would be expected in any interview.
But I'm slightly confused, I suppose, Mr. Baird. Does wearing a suit qualify you to do the job?
It doesn't necessarily. However, wearing a suit is something that's usually expected in most interviews.
Perhaps that's because of a subjective criteria that the individual is presentable, smart, conscientious to make such an effort in an important meeting. Would that be a credible assumption?
It's a possibility.
Okay, thank you. So, I suppose, to put it very broadly, if I may rephrase from where we started, do you accept that there are perhaps a number of different factors, including subjective factors, that an employer might consider as part of a recruitment process?
I accept that there may be a number of factors, however, each sort of job has different factors. So, if you're working in construction, for example, you wouldn't necessarily have to.
Of course, but in different roles and with different companies, there are different things that may be taken into consideration.
Mr. Deere, I'm sorry, I'm not quite sure where you're going with this line of question. And are you suggesting that the fact this witness is gay was a factor that your client was entitled to take into account?
Not at all, sir. I'm simply trying to get to a point where Mr. Burnish accepts that there are more than just, there's more than just simply one factor that may be taken into consideration, including subjective ones.
Well, can you put that very specifically to him, and then can we perhaps move on?
So, again, in summary and conclusion, Mr. Burnish, do you accept that subjective factors may play a role in the recruitment process? For the avoidance of any doubt, I'm not suggesting that protected characteristics shouldn't be included in those factors.
I accept that each job or the person should be fit for the job description. Yes, absolutely. However, each job has its own merits and each interview will therefore be different.
Indeed.
Depending on the sector.
Well, there we are, Mr. Deere. I don't think you're going to get any more out of the witness on this point.
Thank you, sir. So, I suppose if I may now turn to your second interview, the one that took place with Mr. Bigot, the second respondent. You say at paragraph 5 that your first interview had gone well, but this second interview did not go as well. Is that correct?
That's the impression I got, yes.
You also say, in the same paragraph, paragraph 5, he had taken instant dislike to you.
Again, that was an impression I got.
Just confirm from the comment you made earlier, Mr. Burnish, you hadn't met Mr. Bigot before, had you?
Not prior to the interview.
And he's not known your sexual orientation at the start of that interview?
At least I don't think so.
You say in your initial application on the ET1, and if I may take you to page 8 of the bundle, paragraph 3. You say that Mr. Bigot asked you inappropriate questions about whether I was married. In your witness statement, you use a slightly different phrase. Indeed, you say, he kept asking me if I had a girlfriend. Is that correct?
I'm not entirely sure what was said, however, I remember being asked something along those lines, and all I know is it was a very personal question that shouldn't have been asked regarding my marital status.
But despite the perhaps insulting and inappropriate nature of the question as you saw it, you cannot clearly remember what was said.
To be honest with you, I must have been flustered at the time and surprised at whatever was happening. So I'm not entirely sure exactly why there's a discrepancy. However, I know that the question was definitely along the lines of marital status, which was very personal and shouldn't have been asked.
Okay. But irrespective, I suppose, of which was the actual term used, the fact of having a girlfriend or a wife is not in itself conclusive proof that an individual may be gay or heterosexual.
Not necessarily. However, by narrowing down choices, you're obviously asking a very specific question.
Okay. At paragraph 3, again, of page 8 of the bundle, this is your EC1.
Yes.
You state, I believe he, that being Mr. Bigot, took account of my gay pride bracelet that I was wearing.
Sorry, Mr. Deere, could you just go a little bit slower? I'm trying to keep a record of
course, my apologies, sir.
Questions. Sorry, you were saying.
So if I may quote from the ET1, I believe he took into account my gay pride bracelet that I was wearing, and this was the reason he did not give me the job. In your witness statement on the same issue, Mr. Burnish, you say that you were wearing the bracelet discreetly. This is at paragraph 7 of your witness statement. By that, I take it you mean that you were not brandishing around, perhaps you were wearing it under the cuff of your jacket or shirt.
May I just refer to my statement?
Of course.
Whilst Mr. Burnish is looking at his statement, Mr. Ross, do we have this bracelet?
No, sir, I'm afraid not. I understand that it's no longer available. It was a relatively flimsy bracelet and unfortunately it's broken and thrown away.
Incidentally, sir, I was actually intending to question Mr. Burnish on the fact that I happen to wear a similar bracelet myself, although for a different cause. And I was actually hoping Mr. Burnish would be able to furnish us with the answer to the question before I was moving on to this point.
Could you repeat the question, please?
That you describe yourself as having worn the bracelet discreetly. By that, do I take it you mean perhaps you wore it under the cuff of your jacket or shirt?
Again, I can't remember entirely where it was worn, but essentially the point of me saying discreetly is it wasn't I wasn't there in the interview.
Indeed. So, given your conscious efforts to make this bracelet discreet,
yes,
is it possible, therefore, that Mr. Bigot never saw the bracelet,
I think it's impossible.
despite your efforts to keep the matter discreet, or to keep the item discreet, I should say?
I really don't believe that would be possible, because one way or another, I've seen your, I can see you've had it discreetly there, and it's...
Witness finished. Go on, Mr. Burnish.
I can see that you've got your wristband discreetly on, but I have, however, seen it. At various angles, it's quite easy to spot these things, especially when the colours are bright, like yours.
Before I drew attention to it, Mr. Burnish, had you seen it?
Yes, I had.
Okay. Out of interest, we're sat in a fairly formal, almost office-like environment. Can you read what's said on the bracelet?
Currently.
On my bracelet, yes.
On your bracelet?
Yes.
Well, it would be impossible
If
from
I
here.
were to pass it to Mr. Ross, perhaps, who maybe sat at a similar distance that Mr. Bigot may have sat from you on the day of the interview, do you think you'd be able to see it from there?
Well,
Mr. Dear, sorry, can you just move that folder so members and I can see your colourful bracelet? Thank you.
Do you believe you'd be able to read it from where, perhaps, say, Mr. Ross is sat?
there's no way of telling.
Would you like me to pass it to him so that you can read it? Now, Miss Burnish, can you read what is said on the bracelet?
I think it's beside the point. They're different bracelets. The actual font on my bracelet is dark black against a really colourful background. It's very obvious to spot. Yours, however, is just debossed, which is quite easy. It's very difficult to read.
It's a fair point,
it's not
Mr.
the same
Burnish.
thing.
However, is it...
Let him finish, Mr. Dear.
It's just not the same thing.
It's a fair point, Mr. Burnish. However, do you think it is possible that given the discreet wearing of the bracelet, the distance at which you were sat, that Mr. Bigot did not recognise what the bracelet was for?
No, because it's quite an obvious bracelet, and with the colour of the rainbow as well, I think it's quite difficult to not miss or to not see that.
Mr. Burnish, sorry, can you just give us a description, please, of the detailed description of the bracelet? I think that would help.
Yes, of course.
The members and I. Can you just tell us what it looked like and what it said on it?
Yes, can I just...
Yeah, absolutely. Take your time.
It's just a very colourful bracelet, which it's quite obvious to see the black font, which quite clearly says Pride on there.
Does it say Gay Pride?
I believe it does, however I don't have it.
It's black font writing
From what I can remember.
against a colourful background. And as far as you remember, I just want to get this down precisely. As far as you remember, it said Gay Pride.
Yes, as far as that. So it's quite an easy spot.
And that's the basis evidence, Mr. Dear, if that helps with your cross-examination where you're going.
Thank you, sir. I suppose one final point in relation to the bracelet, Mr. Burnish. Is there any rule that only members of the LGBT community are entitled to wear such a bracelet?
I don't believe so. However, it is often the case from a lot of people I've known that it has been members of the LGBT community that would wear it.
But in fact, am I correct in saying that Gay Pride is a cause for the promotion of rights and equality?
Possibly, however, the majority of people I know that wear these wristbands are from the LGBT community, and then looking at questions that narrowed down my marital status, it's quite obvious that this individual was trying to ask very specific questions.
So, did Mr. Biggett ever actually ask if you were gay?
Well, he couldn't.
Did you tell him?
He could, that would not be part of the interview. That would not be anything to do with me being right for the job.
But did at any point during the interview process, did you establish categorically with Mr. Biggett that you were gay?
That's not something we necessarily. Why would you talk about that in an interview? That's not something that legally John could say, and therefore there would be no reason for me to talk about it. It would be something that would never happen. I think that would be bad for his career, if anything.
So, therefore, in which case you are accepting that Mr. Biggett was aware it would be inappropriate to ask this question and to form a view for recruitment based on your sexuality?
I'm not accepting anything because I don't know if he was aware. However, I think this may be the case.
But if I may, Mr. Burnish, you just said that it would be inappropriate for him, it would be bad for his career to ask you that question during the interview.
Well, who would ask that question? I'm not talking about just this particular situation. Any interview you go to, you would never be asked that question. I think that would be a no-no. But that does not mean that the individual's aware. It's just something that people know not to do. It does not mean that they know or they're aware of discrimination rules.
However, you've said already that you believe that Mr. Biggett took an instant dislike to you at the start of the interview. Is that correct?
That's how I felt. I really had a very negative feeling.
But at no point during the interview was any categorical evidence delivered to him that you were in fact gay.
But you get that feeling when you get asked questions about your marital status. I think it's quite difficult to then think about anything else, and that's when I really started spotting other things.
But it's fair to say Mr. Biggett had already, in your mind, formed a disliking of you before he asked those questions.
I really don't know when he formed a disliking of me.
Well, you've just said, Mr. Burnish, and you said in your witness statement that you felt he formed that disliking of you at the start of the interview. It was an instant dislike.
Not necessarily instant, not necessarily. I think, again, I don't remember the exact time, however, I knew that there was a dislike. You know when this is happening.
So, just to address this particular issue in the wording that you used, you no longer accept the accuracy of the wording you used in your witness statement.
Can I just refer to my statement,
of course,
please, to see what I have said?
Again, take your time, Mr. Burnish. We need to have this issue properly evaluated.
Yeah, so as I've said, this is the impression I got about the dislike.
So could we please clarify, Ms. Berge? Did you feel it was an instant dislike to you, as you say in your witness statement?
I mean, in the heat of things, I may have felt that way. However, I'm not necessarily sure and can't remember exactly when the dislike was, but I know that there was a dislike for sure. I can confirm that.
But you now say you cannot remember when that emerged or when that feeling came about you.
How do you define instant? Instant could be after 10 minutes, it could be after 1 minute, it could be as I walked in the door. So that's something that I found a bit difficult to remember, that those first 10 minutes. But that's, again, in the heat of things, I was surprised at what was happening. I couldn't believe it.
Well, especially, you've had a few months since this claim was first issued. You've had the benefit of legal advice. You're now saying that having written your witness statement as you have, you're now not sure.
I'm not saying I'm not sure. There was a dislike. I'm saying that there was a dislike.
Okay,
Mr. Chair, I think we've taken this point as far as we can, if we can move on.
Thank you, sir. You set out in paragraph 7 of your witness statement, Ms. Bernish, that you contacted your friend Charlie, who told you that Mr. Bigot had asked her if you were gay. Is that correct?
May I just repeat this?
Of course. It's in paragraph 7, was the bottom page 2.
And you say, could you just repeat this?
It's just to ask you to confirm that you contacted Charlie and that she told you that Mr. Bigot had asked her if you were gay.
That's correct.
Did she tell you what she said in response to his question?
I'm just referring to the statement. I don't believe so.
Did she tell you if Mr. Bigot said anything about your application or your likely chances of success in the role?
I'm not necessarily sure, but I will check what I've said just to remind myself.
Of course.
I don't believe so.
No, thank you, Ms. Bernish. Out of interest, I know that you said in your witness statement that you understand Charlie's concern that she may lose her job if she came forward. You said in paragraph 12, she's not wanting to be bothered because she might lose her job, and that she has a young family that does not want to take the risk, but you understand her concerns.
Yes, I do understand why the individual, my friend, would not want to take the risk, or I wouldn't want to take the risk of them losing the job.
And yet, you've mentioned in your witness statement categorically what Charlie told you. There is no further information.
Right. So
despite her concern, you still disclosed the information for Miss Bigot to be able to read.
that wasn't. Can I just check again what I've said here
Of
in
course.
relation to what really happened?
Mr. D, I'm also very conscious of time.
Indeed, sir, I have one final point to make, if I may.
Again, this has nothing to do with my friend. Absolutely nothing to do with him.
No, I'm simply saying, Mr. Benish, that you say that your friend who gave you this information was not prepared to come forward for fear of reprisal from Mr. Biggett. However, you in your witness statement have told us exactly what she told you, if you just confirmed to us.
Right. Well, I didn't confirm anything. I haven't confirmed exactly what was said. So,
You explained to us that Charlie told you that Mr. Biggett asked her if you were gay. I asked you a question.
He did ask that.
And you said yes.
This is what was, I believe,
Yes.
was said. Again, I can't know whether or not.
Okay,
And I'm not sure, Mr. Deere, that that's going to assist us with our
No,
decision.
so I shall move on. I will just quickly summarise the situation, if I may, Mr. Birch, and then ask you a particular question rather than go through it point by point. At paragraph 10, you explained to the tribunal that you met Sarah Miles by chance in Didcot. By this point, you'd already raised an issue with the recruitment agency and asked if you'd been refused the role because you were gay. After your meeting with Sarah Miles, you say that you wrote to the HR department to ask if you were refused the role because you were gay. So, despite being well aware of the suspicions that you already had, on meeting one of the directors of the company who interviewed you for the role, you didn't ask her if the reason you were rejected was because of your sexuality.
Do you think she would answer that honestly, even if she knew?
My question was, did you ask her?
Did you ask her, Mr. Burnish?
I don't believe so. I really don't remember doing so.
Is she any more or less likely to answer that question than a recruitment consultant or an HR representative?
Sorry, Mr. Deere, he can't go into the mind of this witness and anticipate how she would have.
I appreciate that,
That's
sir.
not fair.
Thank you. And finally, if I may, Mr. Burnish, the offer letter that we referred to earlier at page 26 of the bundle,
Yes.
based on the wording and terms of that letter, do you accept that you were not guaranteed a pay rise from your employer to £40,000?
Based on the letter itself and nothing else.
Yes. I may direct you to the third paragraph, which refers to your salary.
And your original question was?
Do you accept that you were not guaranteed the pay rise from £37,000 to £40,000 by the terms of that letter?
Not necessarily. I mean, you could interpret this in a variety of ways. It does say there's a salary review as well.
Indeed, yes. It says, however, please note there is no obligation to provide you with a salary increase.
But there's no obligation either way. There's no obligation
Indeed.
to also curb that to
But there's
737.
no obligation to do so. Can you confirm, did Mr. Biggett himself tell you you would not receive a pay rise?
That, again, not getting the job, there's no reason why. I mean, I still need to check what was said, however.
I'm simply asking, was it Mr. Biggett or your current employer who made the decision about your pay rise? Or rather, who informed you about the decision of your pay rise?
may, from what I can remember, may have been my employer, my current one.
Your employer
May.
informed you about your salary. As far as you're aware, Mr. Burnish, at the
Mr.
time,
Dean, you did say you had one further question. That was about 4 or 5 questions ago.
as far as you're aware, Mr. Burnish, at the time that you alleged that Mr. Bigot contacted your current employer, was it simply you, he, Ms. Miles, and your friend Charlie who knew you'd applied for the job?
There's no way of telling that. I mean, we'll have to spread very quickly, right?
So is it possible that other people knew and may have told your employer?
Not in this case. I think that's no. Well, who would call my employer?
But I'm just saying, is it possible that other people knew and could have told your employer?
I find that difficult to believe.
Despite the fact that, as you say, word had spread quickly.
Amongst the people that we're talking about.
Thank you, Mr. Burnish. Any other questions, sir?
Thank you, Mr. Deere. Mr. Burnish, if you just wait there for a minute, let's just see whether members, first of all, have any questions you want to clarify.
Yes, I'm interested regarding the actual job title, Customer Service Manager. Obviously, you said that you were employed as one, you went for the position.
Mm-hmm.
Can you give me an understanding of the sorts of levels of responsibility, rather than just a job title? What were the similarities or maybe the differences within that role that you were applying to further your role?
Well, there would be a lot more responsibility in the other role and possibility to grow. Do you want a job description of what I'm currently doing?
If there are any specific differences, I'm just trying to get an idea of the
Specific
sort of difference
differences.
in the wage, that why you were.
I think it's more the fact that within the other role there's more of a chance to grow, and they're quite similar in a way. So I definitely have the transferable skills to work for the other company, if not better. So again, I think it was more or less the growth side of it that made me want to.
So you didn't feel that your current company could bring that because you were thinking that you were going to get a pay rise?
That's how I felt, but it wasn't necessarily about the pay, it was about growing. Yeah.
The other was just sort of thinking about when you said about when the dislike was formed. When you were being asked these questions, did you feel that Mr. Bigot was trying to seek a reason for not recruiting you in the questions the line of questions that he was taking?
I think it was yes, but there was a specific reason, and that was my sexuality. It was just very obvious. You just know when these things are happening, and the questions we did narrow it down to that point where it was pretty obvious.
Thank you.
Any questions for these?
Just one from you. Mr. Burnish, how long did the interview last?
I'm not entirely sure. By the end of it, I'd completely.
A rough estimate. 5 minutes, 20 minutes?
Again, it would be so rough, so is there any point in me providing that time?
Well, give us a rough idea, Mr. Burnish.
Yes. I'll just try and remember. See if it's...
Just roughly.
Maybe 40 minutes, but it might, again, I don't remember.
And you mentioned that Mr. Bigot asked you questions about your personal life. Can you just give an idea of some of the other questions? Were there other questions?
To be honest with you, I felt there were questions that were kind of leaning towards my marital status, which is why I mentioned that term. So I believe there may have been others too. and it was pretty obvious by that point that it was heading towards a specific direction. I don't specifically remember the questions. I couldn't possibly transcribe or remember them, but I do feel they were key.
Thank you.
Members just saying whether or not you asked for a copy of the interview. Is that something that you asked for
Sorry.
as part of your tribunal proceedings? And it may be a question for Mr. Ross, but the member was just wondering whether we have a copy of the notes of the interview that were taken by Mr. Biggers. Are you aware of that?
So it says we've not been provided with a copy of the notes during exchange of documents.
Did you request them?
Yes, sir. Our understanding is that they don't exist at all.
Is that right, Mr. Deere?
That is correct, sir. The interview is only attended by the directors in question, so Ms Miles and Mr Biggett on respective occasions.
And no notes or minutes were taken of the interview?
And not that I have seen, no, sir.
It's slightly concerning, Mr. Deere. Well, I have to say, I would have thought that notes would have been taken of the interview carried out at director level. You're telling me that they weren't. Is that right?
I've not been provided with any notes, sir.
Well, Mr. Deere, there's a difference between you not being provided with the notes and whether or not those notes are in existence.
I'm not aware that any such notes are in existence, sir.
Okay, well, we'll consider that when we come to our decision. Mr. Burnish, I just have a couple of questions for you, one or two things that I'd like you to clarify. You say that you have been having, that you had counselling sessions, and I think you paid for those sessions privately. Could you just tell us a little bit about what those sessions were for, and can you tell us how much you paid for the sessions? You said I've been very upset by how I've been treated. I've undergone a number of counselling sessions.
They were, I believe, £150.
How many sessions did you have?
5, I think.
Just one other point. If you are successful, Mr. Burnish, and of course the tribunal will not be making any final decisions until the end, part of your claim is for injured feelings. Can you just tell the tribunal how you felt? You said that you've been discriminated against on the grounds of your sexual orientation. How did that make you feel, and what impact did that have on you?
I was obviously very hurt. I felt lost and also hopeless. I couldn't believe that this was happening in the 21st century.
Thank you, Mr. Burnish. Mr. Ross, just very briefly, again, I'm conscious of time. Do you have any re-examination arising out of the questions put by the...
Not that I think will take us any further forward, sir, so I'll leave that. Thank you.
Okay. And Mr. Ross, do we know any more about this witness?
I'm afraid she hasn't yet arrived, sir. If it pleases the tribunal, I'd suggest perhaps if we moved on to the respondent's evidence, and I will let you know as soon as the second witness arrives. Okay.
And Mr. Deere, are you happy for us to proceed pending the appearance of the witness?
I am, sir, yes, thank you.
Okay. In that case, shall we move on to your evidence, Mr. Deere?
Indeed, sir.
If you'd like to return to your seat. Thank you very much, Mr. Brown. And who are you calling first, Mr. Deere?
Our first witness, so is the second respondent, Mr. John Biggett.
Mr. Biggett, if you'd like to take a seat.
How would you like to take the oath?
Oath, please.
Please place your hand on the Bible.
I swear by Almighty God that the evidence I shall give will be the whole truth. Sorry, the truth, the whole truth, and nothing but the truth.
Please take a seat.
Mr. Biggett, as you've just seen with Mr. Burnish, I'll just ask you to turn to your witness statement, a copy of which should be in front of you. And could you just confirm that is your correct name and your working address?
I can confirm that is correct.
Thank you. And that the signature shown that the back of the witness statement is your own?
Yes, that is my signature.
Thank you. Then, as Mr. Burnish has just done, for the benefit of the tribunal, could you take your time and read through your witness statement?
Of course. I am the commercial director of Clean and Smart. I have been with them for 20 years. I'm happily married to my wife and have 3 adorable children. I am also a education. In April 2016, I interviewed Gideon Burnish for a role as customer services manager. This is a key role for us at Clean and Smart and would report jointly into me and the sales director, Sarah Miles. I have an excellent team in the commercial department. We have many family events together. All of our children know each other and we all look out for one another. It is very important that whoever comes into the role is able to join us as part of the team, not only in the office but outside work as well. Sarah had interviewed Gideon Burnish and thought he would be an excellent candidate. I was entirely unconvinced. He did not seem to answer the questions I asked him directly, and I was very sceptical about his experience. Indeed, after he raised these discrimination claims, I actually contacted his current manager and genuinely believed that his experience was not to the levels Mr. Burnish described. His manager was obviously surprised to hear that he had been looking for another job. When HR asked me if I had not given the job to Mr. Burnish because he is a homosexual, I was incensed. I make a decision based on what is best for the company, and I do not make decisions based on people's sexual proclivency. God, I've lost the word. Given on that. Their private life is their own, and whilst it may not be one that I approve of, I do not make decisions based on their private life, only what is best for the business. In fact, we appointed a first-class customer service manager who has fit right in, and all of his children have already been into the office and have met them and his wife. He is also very good at his job. However, due to recent fall in sales, unfortunately, we have made him redundant after 5 months, and we have decided we will no longer need a customer services manager. The company take equal opportunities very seriously, and we all receive training, and we all receive a training course telling us what is and is not acceptable in the workplace. I have personally attended this course 3 times, and I know everything about discrimination in the workplace.
Mr. Chair, do you wish to put any additional questions to this witness, or will you?
No, thank you, sir.
In that case, Mr. Ross, it's over to you for a cross-examination.
Thank you, sir. Morning, Mr. Biggett.
Good morning.
It's right that you're a commercial director of the company, aren't you?
That is correct, yes.
And you're a devout Christian, aren't you?
Very much so. I attend church every single Sunday.
And you're quite clear that you don't approve of homosexuality, aren't you?
I believe, in the eyes of God, it is incorrect, yes. However, I would never discriminate against an individual based on that.
At paragraph 5 of your statement, and I don't blame you for struggling with the word, at this time of the morning proclivities is very difficult. But the important bit is, you say their private life is their own. That's not right though, is it? You don't believe somebody's private life is their own, do you?
My personal opinions and the opinions of the company are 2 very different things.
I'm not asking about the company's opinions, I'm asking about your own. You don't believe somebody's private life is their own, do you?
I believe that we were all put on this earth by God, and I believe that God would want us in wedlock.
At paragraph 3 of your statement, you say that the families, children, all know each other and you look out for one another.
That is correct.
And it's important that if somebody comes into the business, at the end of that paragraph you say that they join us as part of the team, not only in the office, but outside of work as well.
Yes, I think that's very, very important. I've been with this company for 20 years, and we in fact pride ourselves on building great relationships, and we're all friends, and I think that's important to a growth of a business and making it a nice place to work.
So you expect your employees to share their private lives then, don't you?
I expect them to make an effort to build relationships, yes.
And that's why you asked the claimant about his private life during his interview, isn't it?
I believe that my questions to the claimant were entirely innocent, and I wanted to build that relationship on the personal level, so I was showing an interest in the claimant.
So you did ask him those questions during the interview?
Which questions do you refer to?
About whether he was married, whether he had a girlfriend.
Yes, and there is absolutely nothing wrong with me showing an interest there.
You can understand how that might be misinterpreted though, can't you?
I find it difficult to understand.
Well, the reason you asked the claimant those questions is because you wanted to know he was gay, isn't it?
Absolutely not. As mentioned in my statement, I have attended 3 very in-depth courses, so I understand exactly how I can and cannot discriminate. They're 3 very, very in-depth courses, so I know everything about this.
Are there any notes of that interview?
No. I'm a man who likes to keep things in my head. So it would put me off the interview by writing notes.
I suggest to you the reason there are no notes is because you don't want anybody to see the questions you were asking.
I would say that's ridiculous.
After the interview, you went and spoke to Charlie Cross, didn't you?
I have no idea whatsoever. I speak to Charlie is a member of my team, so of course I would speak to her. Why wouldn't I speak to her?
We're going to speak to hear from Miss Cross later on today.
Okay.
So did you go and speak to her immediately after the interview?
I've got no idea. There is a good chance that I did. There is a good chance that I didn't. I share an office with her.
You knew that Miss Cross was the claimant's friend, didn't you?
I believe so, yes.
Which is why you asked her if he was gay, didn't you?
There is a good chance that I did, yes.
And you made it clear to Charlie that you wouldn't be appointing the claimant because he was gay, didn't you?
That's absolutely incorrect.
Well, you say in your statement today that the reason you didn't appoint the claimant was because you were sceptical about his experience. That's right, isn't it? If it assists, that's at paragraph 4 of your statement on page 2.
Yes, as you are aware, we interviewed several applicants, and we felt that we interviewed an applicant that had more experience and more suitable experience.
I'm not asking about another applicant's experience. I'm asking you whether you were sceptical about the claimant's experience. That's what you're saying here in your statement.
I was, yes.
Well, that's not true, is it?
It is true.
It's not the reason that you told Sarah Miles that the claimant hadn't taken the job. You told her that he'd rejected it, didn't you? I can't remember. And you told the recruiter that it was down to a personality fit, didn't you?
The personality fit, as I've previously alluded to, is absolutely vital in a small business. Like I said, we all socialise outside work, and personality fit is vital.
Well, let's go to page 27 of the bundle, if we may.
Can you just identify what this is, Mr.
Yes, sir. This is an email from the claimant's recruitment consultant to him explaining the reasons that she was told he wasn't successful for the job.
Can you just pause so that we can read this? This is from Katie Stevenson, is it, on the 20th of April?
Yes, sir.
Dear Gideon, further to my call, I'm writing to confirm that the reason you were unsuccessful for the role is that the company felt that although you had the right experience, you were not the right personality fit for them. I'm really sorry you weren't successful on this occasion, and I will help to keep looking for the right role for you. Kind regards, Katie Stevenson.
Yes, sir.
Thank you.
So it's clear there that you told the recruiter that the claimant did have the right experience, didn't you?
It appears that is what Katie has told that's what Katie's told Gideon, yes.
Well, put to you that this is an email from the same day, and that it reflects the conversation you had with the recruiter, because that's what you believed at the time. There was nothing wrong with his experience at all.
I would certainly argue that I would be well within my right to believe that he lacks experience, but also that there could be a discrepancy in the personality fit, let's say.
Well, experience is only being raised as an issue now because you don't want the real reason to be known, that you chose not to appoint the claimant because he was gay.
That is incorrect.
Paragraph 4 of your statement, you say that you contacted the claimant's current manager to ask about his experience after he raised these claims, don't you?
Yes, I do.
And I understand this date is accepted between the parties as the date that the call took place, so it's really to provide the tribunal with some evidence on this point, but can you confirm if the call took place on the 30th of August, please? That's right, isn't it?
Yes.
Forgetting this particular call for a moment, how would you feel if another employer called you and said they wanted to ask you some questions about a star employee at Clean and Smart?
I would understandably be disappointed and
You'd be frustrated, wouldn't you?
I would be frustrated and
annoyed?
Annoyed, and probably the word that you use of star employee, we would probably do everything we could to keep them.
So you knew that contacting the claimant's employer would make things difficult for him with his current employer, didn't you?
I may well have done. That certainly didn't cross my mind whilst making the call.
Okay, so you did that deliberately because you brought these claims, didn't you?
Absolutely not. Are you suggesting that I did this to get my own back? Is this what you're suggesting?
Absolutely right. We know from the email to the recruiter that you felt the claimant's experience was suitable. It's clear that the only reason you contacted the claimant's manager is because he brought these claims against you.
Can I just take you back one step? How can you tell me how it's clear that I believed that the experience was suitable? Where have I said this?
Well, Mr. Biggett, he showed you this document earlier, and it says, from the recruiter, the company felt that although you had the right experience, you were not the right personality fit for them. Now, Mr. Ross has just put that to you, and you seem to accept that that's what you had said. Are you now changing that?
I'm saying that as an employer, I have the right to look at a number of factors, and we undertook a fair recruitment process, and as a result of the fair recruitment process, we went for a better.
Mr. Biggett, did you or did you not think the claimant had the right experience?
I felt he had okay experience.
Mr. Ross, if you like to...
Thank you, sir. Paragraph 7 of your statement.
Yes.
You say that everyone's attended a course about equal opportunities and you know everything you need to know about discrimination in the workplace.
Absolutely.
So you understand that you should not discriminate against somebody because of their sexual orientation, don't you?
Correct.
And you understand that not offering a job to somebody because of their sexual orientation is discriminatory, don't you?
Of course I do. I've attended this course 3 times.
And you understand that you should not victimise somebody for enforcing their right not to be discriminated against, don't you?
Absolutely. But this case includes no areas of discrimination, so it's irrelevant.
Yeah, that's exactly what you did here, isn't it?
Absolutely
You
not.
chose not to appoint the claimant because he's gay. And when you found out he'd issued these proceedings, you called his current company to deliberately cause trouble for him, didn't you?
Rubbish. Absolutely rubbish. I'm a strong Christian, and I'd never be so petty.
Thank you, sir. I have no further questions.
Thank you, Mr. Ross. Any questions?
Yes. John, you say that you obviously a devout Christian. I saw that you swore on the Bible. May I ask about the other staff members that you have in your company? How many staff do you have? Rough, I'm not expecting. We're talking 10, 50?
50.
50. Okay. And of those members of staff, would you say that there's a good mixed diversity? Can I say, do you know how many are Christian, how many Muslim, how many are of other faith, agnostic? Would you know that makeup? Do you monitor equal opportunities?
Not off the top of my head. I do know that a massive part of what we do here is a number of employees go to church together, but aside from that, I have no idea.
And you mentioned about being an all-inclusive company where you go out outside of work. There must be members of your staff who have other commitments that might not be able to join in. How do you ensure that they feel part of that company if they can't attend church or what have you?
That wouldn't come under my remit.
I think just one, if I may, yes. I'm slightly concerned about the discrepancy about the experience. To sort of say in one breath in your statement that you were sure that he was sceptical about his experience, and then to having an email where you say that he did have the right experience. Could you say where you felt that he fell short of that experience? You must know from your memory, I know you don't have notes, but from your memory, what were the key specific points where you felt his experience was lacking?
From memory, I don't think my concern, experience-related concern, was in a particular area. I see this that 2 candidates applied for the position. I interviewed 2 candidates, and whilst Mr. Burnish, his experience was fine, I feel that the successful candidate had stronger, relevant experience within one of our competitors.
Mr. Bigot, you stated that you saw a fair recruitment process, and
Yes.
you ran a fair recruitment process. Just now you've said 2 candidates. I heard earlier, correct me if I'm wrong, several candidates. How many did you interview?
2 at the final stage, but we had multiple applicants, as we always do.
Okay, so 2 were put forward for you for second interview.
Yes.
How do you prepare for your second interviews, to conduct your second interviews? What preparation do you do?
I'm very experienced, I don't need to prepare, and I really
So you don't read the CVs?
No, I'm incredibly experienced. I've been within this business for 20 years, and I completely get what it takes to be successful here. Therefore, there is no real need for me to prepare. I trust my colleague who has already given an opinion, and I'm willing to the stamp on this.
Okay, so do you ask the similar questions, the same questions to candidates?
Similar, I would imagine.
There's no preparation, no notes.
No. I have a fantastic memory, so I keep everything in my head.
Thank you.
And Mr. Biggett, just a couple of questions from me. You've told us boldly and confidently that you know all there is to know about discrimination law, and you've been on this course 3 times. I'm aware that an important aspect of those discrimination courses is about records and record keeping. Given that you've been on the course and you've absorbed everything you need to know on the course, can you tell us again why is it you chose not to keep any records of this interview?
As I previously stated, I'm very experienced. I know this business better than anybody. I've been here 20 years, and I've hired several successful team members. Therefore, I believe notes aren't important because I'm able to make a great decision there and then, and I do get it right every time.
Right. And just one other point. You said that the reason you didn't offer the job to the claimant was because he wasn't the right personality fit. What exactly was it about his personality, in your mind, that led to your decision that he wasn't the right person for the job?
We have a very open culture here, and I felt throughout the interview process, Mr. Burnish almost avoided a lot of my questions and gave very, very roundabout answers.
Are these your questions about whether he had a girlfriend or a wife?
I can't remember, but yeah, he seemed like he was hiding something, which clearly proved to be the case when I spoke to his current manager.
Thank you very much for your evidence. Mr. Deere, have you got any re-examination arising from the tribunal's questions?
Only to ask Mr. Biggett if you may confirm, sir. You commented to the judge a moment ago, Mr. Biggett, that you always get it right when you recruit. Could you confirm whether or not you faced proceedings like this in the past?
Absolutely not. No, I do always listen.
Thank you very much, Mr. Biggett.
Thank you.
for the question, sir.
Can we turn to your seat? Mr. Biggett, thank you very much. Now, just in terms of where we are, gentlemen, you have one further witness, Sarah Miles, the sales director. Can somebody update me where we are on this witness, Mr. Ross? Have you seen any sign of Charlie Cross yet?
My understanding, sir, is that she's made it to Didcot train station and
Good.
is in a cab, so she should hopefully be here in the next 5-10 minutes.
Good. Shall we press on then and hear from Mrs. Miles, and then perhaps if Mrs. Cross is here, we can hear from her at the end.
Thank you, sir.
Okay. Would you like to call your next witness?
Yes, sir. Thank you.
How would you like to take the oath?
From the Bible. Okay, thank you. I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you, please sit.
Good morning, Ms. Miles.
Good morning.
As you've just seen with the 2 other witnesses this morning, could I just ask you to turn to the copy of the witness statement that should be in front of you?
Yeah.
And could I ask you to confirm that the name and address shown at the top of that witness statement are your correct name and your correct work address?
Yes, I can confirm that's correct.
And could I also just ask you to confirm that this is your signature at the back of the witness statement?
Yeah. That's correct.
Thank you. Now, if I could just ask you to follow, as the other 2 witnesses have done, to just read aloud the witness statements for the benefit of the tribunal.
I am sales director of Clean and Smart, and I've been with them for 5 years. In April 2016, I interviewed Gideon Burnish for a role as Customer Service Manager. This is a key role for us at Clean and Smart and would report jointly into me and the Commercial Director, John Biggott. I interviewed Gideon Burnish in April 2016 and I thought he did show promise, but my fellow director, John Biggott, did not think he was right for the role. He was therefore not appointed. I do not believe this was on the grounds of Mr. Burnish's sexuality. The company takes equal opportunities very seriously and has a regular training programme for all employees, which takes them through what is and what is not acceptable in the workplace.
Thank you very much, Miles. So I have no further questions at this stage.
Thank you. Mr. Ross, it's over to you for cross-examination.
Thank you, sir. Miss Miles, it's right that you initially carried out an interview with the claimant, isn't it?
Yes, that's correct.
And you say at paragraph 3 of your statement you thought that the claimant showed promise.
Yes,
don't you?
absolutely, yes.
That's not quite right, is it? You thought he was an excellent candidate, didn't you?
I did, but different people have different perceptions of the word excellent.
Okay, so it's a little bit different to say somebody shows promise and somebody is excellent though, isn't it?
Not really. He did show promise and he was excellent in some categories, but people's opinions differ.
So is it fair to say that you had no doubts about the claimant's capability or his experiences?
I had no doubts in that first interview, but obviously, you know, it wasn't, the decision was not just down to me.
So if you had no doubts about his experience, Mr. Biggott should have had no doubts either, should he?
Well, as we've clearly heard from Mr. Biggott's evidence, he has been in the industry for 20 years, so you know, we have to take that into account, that he probably knows far better than I on these matters.
About a week after the interview, you spoke to the claimant in the high street, didn't you?
Yeah.
And you told him that you were surprised that he hadn't taken the job, didn't you?
I think it was just a bit of a miscommunication. I was under the impression that, you know, that he had been offered the role and he wasn't, just a bit of a scatty moment.
Well, you say miscommunication. You were quite clear in what you told the claimant, weren't you? You told him that he had rejected the role. You were surprised that he had rejected the role because it wasn't enough money, didn't you?
Well, I think it was a very busy Saturday afternoon. It was a very busy street with lots going on. So, you know, again, tittle tattle in the street. It's you know, it's a bit of hearsay, really.
But that's what you told him, isn't it?
I can't remember.
I have no further questions. So.
Thank you. And just help me with a couple of points, Mrs. Miles. What exactly did Mr. Biggott say to you in terms of the reasons that he didn't think the claimant was suitable for the role?
He gave a very decisive explanation on kind of why he thought that that Mr. Burnish had maybe fabricated his level of experience as a customer service manager. He maybe didn't think that the skills that he'd proclaimed to have were actually present.
And just in terms of your workforce, and the member asked a question earlier about diversity, Mr. Biggott couldn't help us an awful lot. Can you give us any more insight into the diversity or otherwise of your workforce?
Again, diversity is a word that is open to lots of different interpretations.
Well, your common understanding of the word?
That, you know, I do believe that we have a diverse workforce, but I also believe that Mr. Biggott likes things done in a certain way, and you know, as again we've said,
been in the industry for 20 years, so he knows.
Yes, we heard a lot about that from Mr.
He knows what types of people are successful in our industry, and he's brought that with him into the company, and that is reflected in the diversity of the workplace.
Just one other question. Are you aware of whether you have any gay employees within your workforce?
No, I wouldn't know.
Okay, thank you very much.
Thank you.
Re-examination?
No questions, sir. Thank you.
Thank you very much. Mr. Miles, you can return to your seat.
Sir, if it assists, I understand that Ms. Cross has arrived.
Right, excellent. Can we have her in?
Blimey, Your Honour, I'm so sorry. So sorry.
That's okay, Mrs. Cross. Just
Please stay standing.
take your breath and take your time.
How would you like to take the oath?
Oh, on the Bible, I think.
Okay, if you'd like to place your left hand.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth, Your Honour.
Thank you.
Please sit.
Now, Mrs. Cross, you have been witnessed ordered here by the tribunal. The evidence that you'll give is very important to assist us in coming to a decision, so we do want you to answer as frankly as you can. Mr. Ross, I'm going to ask you to put some questions to take this witness through her examination in chief, if you will.
Thank you, sir. Ms. Cross, thank you very much for joining us. I understand the train from Lambeth was a bit difficult this morning.
Yeah, too right.
First off, if you could confirm your full name and address for the tribunal, please.
Charlotte Imogen Cross, 1 Lavender Way, Bright Walton.
And can you confirm who your employer is, please?
I'd rather... Clean and Smart Limited. I work for him.
Thank you. And were you in work on the day that the claimant was interviewed by Mr. Biggett?
I was, yeah.
And giving as much detail as possible to the tribunal, please, can you tell me what happened after the interview, and specifically your conversation with Mr. Biggett, please?
Can I just say I'm not here. They sent me a piece of paper to make sure that I came, because I didn't want to come, so just in case I lose my job. I share an office with Mr. Biggett over there, and he came in and he interviewed Gideon, and he slammed down his book and he said, "Cool, blimey." Well, I'd say that. He said, "I thought you knew this man." I said, I did. He said, "Well, you could have told me he was gay, couldn't you?" And I said, "Well, I didn't really think that was really any interest or anything to do with the job he was going for. I thought he was just brilliant and he'd make a really good customer services manager." And he said, "Well, we can't have anyone gay working here because, they're not going to have kids and they're not going to be able to join in, and, well, they're just not going to fit in." He was a bit cross, really. Sorry.
There's nothing to be sorry about, Mrs. Cross. You're here to assist the tribunal in a very important decision. We do appreciate your attendance.
Thank you very much, Mrs. Cross. There's nothing further from me, sir.
Mr. Deere, now I appreciate, Mr. Deere, that you've not had the benefit of a witness statement, but is there anything that you'd like to put to this witness in cross-examination?
If I may, yes, please, sir.
Absolutely, go ahead.
Good morning, Mrs. Cross. As to echo Mr. Ross's sentiment, many thanks for coming along today to assist us. Just to pick up on a point you just informed the tribunal, you said that Mr. Biggett came into the office that you share with him following the interview, and that he said, "You could have told me he was gay." So, to your mind, before he spoke to you, he already knew that Gideon Burnish, the claimant, was gay?
He seemed to, yeah.
Thank you. Did you confirm that to Mr. Burnish? To Mr. Biggett, sorry.
I didn't really need to, because he said you could have told me, then I just sat there. I didn't really understand why it was of any interest.
Mr. Burnish has told us that he contacted you and that you told him about the conversation that you'd had with Mr. Bigot. So did you tell Mr. Burnish what you just told the tribunal before he made his claim?
In not so many words, yes.
When you say not so many words, Ms. Cross, did you use a very different version of events?
All I said was, he came in, he asked if he was gay, and he seemed very cross about it, and that he didn't want to give him the job because of that. That was my personal view.
So you informed Mr. Burnish that Mr. Bigot had expressly said he would not give him the job because he was gay?
Yes, yes.
And you informed Mr. Burnish before he made his claim?
Why? I mean, he rang me within days.
Indeed.
Yeah.
Has Mr. Bigot ever expressed an opinion like this before?
Well, I mean, he's a very religious man, but that doesn't mean all religious people perhaps share his views, but he's a very family man. He has particular beliefs. I've never seen him be openly hostile to anyone because of their religious orientation, but I think that's the right expression, I think. But no, I mean, it was the first time I'd seen him cross because of somebody being gay. But.
So, as Mr. Bigot has informed us, he's worked for the company for 20 years, he's a commercial director, he's regularly involved in the recruitment process, and he has told us that he always gets it right. Therefore, as far as you're aware, through sharing office with him, he has never made a recruitment decision based on, as you put it, someone's sexual orientation.
Well, I haven't really been there that long, so I know he's been there forever, sorry. I mean, quite a long time. But I can't comment on what he's done before. All I can say is what he did on this occasion, and I just didn't think it was very fair.
Indeed. Ms. Burnish has informed us that he spoke to you before he actually submitted his application to the role, and that you were able to provide some information about the company. So at that time, there was no cause for concern, no alarm bells that you thought you should tell Mr. Burnish that may be a problem with his application?
No, not at the time.
You had no reason to believe that the company or Mr. Bigot may take issue with Mr. Burnish's sexuality?
No, but I mean, in fairness, I don't think we've got anybody else gay in the company, so it would never have come up, really.
Have you asked all employees their sexual orientation?
No, I mean, that wouldn't be right, would it? You don't go around asking people what they do in their spare time.
Many thanks, Ms. Cross. I have no further questions. So.
Thank you.
I'm just asking you made a statement right at the beginning where you said they made me come. May I ask in what capacity you were asked to attend and when this request came in?
Well, Gideon, he asked me if I'd come along as his witness, and I had to explain to him I didn't really want to do that because I'll be sacked. So he explained that the tribunal could make me come and that they could ask and that the tribunal would send me a letter they called me today to tell me that the tribunal had made the order and that I had to be here, which is why I'm a little bit late, sorry. But so I'm not here because I want to be, Mr. Bigot, I'm here because they made me.
If it's just to help clarify, I can confirm an application for a witness order was made by my subsequent solicitor.
So, and the fact you're obviously slightly fearful with having your boss here and listening into your comments, you're still prepared to come in and attend today, so thank you.
Mrs. Cross, how long have you been with the company?
Oh, about 2 years.
And have you ever heard any discriminatory comments by anyone within the company?
No, but I mean, it's sort of a little bit like working with clones, really, because everybody is quite similar. So Mr. Burnish will tend to recruit people that sort of like things he likes and sort of look a bit like him, or obviously unless they're girls, in which case I'm not suggesting, Mrs. Miles, that you look like Mr. Burnish at all, because obviously you don't. But yes, I mean, nobody is different, if you know what I mean.
Yes, understand.
So, you know, his honour here, I mean, we don't really have any black faces in the company.
And we've heard that you don't have any girl employees.
Not to my knowledge.
There's not much diversity, Mrs. Cross, in the company.
Oh, yeah, we have, you know, I mean, we have training on it, but it's sort of, you know, people wouldn't really knew it if it jumped up and bit them, really.
Thank you very much, Mrs. Cross, and once again, Tribunal are grateful to you for coming.
Thank you. Sorry.
Now, Mr. Ross, does that conclude all of your evidence on behalf of the claimant?
Indeed it does, sir. Thank you very much.
And I think, Mr. Deere, we've heard all of your evidence on behalf of the respondent. In that case, we now need to move to closing submissions. Gentlemen, Mr. Deere, it will be for you to go first, and then Mr. Ross, you will have the opportunity to make your submissions. And I understand that you've both prepared very helpfully written closing submissions, which I have and I've read. I don't need you to address me on the law in any great detail. However, you could just, in summary, take me to your legal points. And gentlemen, if you could restrict your submissions to not more than 10 minutes each.
Of course, sir. Thank you.
So before I do begin, may I just clarify, would you like us to address you on the issues of early conciliation and or indeed the application to amend the claim?
Well, what is your position on early conciliation and whether or not the claimant has complied? We know the regime is quite a complicated one, Mr. Deere, and we know that we've had some recent Employment Appeal Tribunal decision on the matter.
Indeed, sir. Just to clarify, as was set out in the respondent's CT3, they initially took the view that Ms. Burnish, the claimant, had failed to comply with Sections 18 of the Tribunals Act and Rule 2 of the Early Conciliation Rules by failing to provide the correct name of the respondent company. However, in light of the circumstances that both parties are now here today, we have prepared and given evidence, and indeed the rulings of recent cases, particularly missed in Derby Community Health Services, that the discrepancy is notable and we've withdrawn that particular application.
Well, that's a very sensible concession, Mr. Deere, and I'm grateful to you for that and not spending more unnecessary time on that. Therefore, would you like to proceed with the rest of your submissions?
Thank you, sir. Look, in relation to the claimant's application to amend his claim, it's my understanding that he intends to present an application for victimisation. The respondents believe that any such amendment should not be allowed as it would be against the overriding objective and principles of natural justice. It places them at a distinct disadvantage if they are unable to obtain all the evidence that may be relevant to that issue and prepare for the hearing, and therefore denies them the right to a fair hearing. The application has been made only today, despite the fact that, as is clearly stated on the claimant's EC1, which was submitted in August 2016 and can be seen at page 1 of the bundle, the claimant had the benefit of professional representation and has had that benefit throughout the duration of the proceedings. And at the time of addressing you today, the claimant has not offered any explanation as to why he was unable to identify the full extent of his claims and or indeed address this issue prior to the final hearing. Regardless of any explanation that the claimant might offer, however, the respondents do not accept there is any justification to extend and to allow the application so late in the day, as there is little or no prospect of success for the claim itself. It's the respondent's view and submission that the law does not cover an application or a claim of post-termination victimisation in respect of a job applicant. It is accepted that following recent case law, the right was extended to employees, but that the case itself is very much limited to employees and makes no mention of applicants, and indeed the recent amendments to the Equality Commission of Human Rights guidance to the relevant legislation, the Equality Act, specifically says that the case law permits workers to present a claim for post-termination victimisation against an ex-employee.
Sorry, Mr. Jones, if I can get this right. You're saying that this particular claimant is not protected by the law as far as his claim of victimisation is concerned.
Indeed, that's correct.
And
sir.
you want the tribunal to find, you want us to find that the law does not extend protection to the claimant for the act of victimisation. Is that right?
In the event that the application to amend is allowed and successful, then I would submit that that should be the correct finding of the tribunal.
Okay, well, we hear what you say on that, Mr. Dean. If you'd like to move on to your next point.
In relation to the more substantive and pre-existing claim of discrimination, i.e. the reason why Mr. Burnish was not offered the job that he was, I think it's accepted between the parties that there is very little documentary evidence in relation to this matter. And the tribunal is effectively presented with a situation of he said, she said, based on the witness evidence. Although the respondents would submit that it's not quite that straightforward, that numerous sources, including the first and second respondents and their representatives, the HR team and recruitment agency, have all confirmed to Mr. Burnish that he was not selected for the role for any reason connected with his sexual orientation. By contrast, we've heard today from both Mr. Burnish and from his witness, Ms. Cross, both of whom gave conflicting, contradicting, and, if I may say, muddled evidence. Ms. Cross has informed us that Mr. Bigot entered the room which they share and stated very categorically that Mr. Bigot would not recruit Mr. Burnish because he was gay and that he could not have anyone working there.
Well, that's right, Mr. Deere, and doesn't that present you with quite a major problem? What am I to make of the evidence of Mrs. Cross?
That I would submit and ask the tribunal to find that Ms. Cross's evidence is unreliable and inconsistent with the other evidence that we've been presented.
Right.
It appears that the claimant's claim very much relies upon his memory of the interview he had with Mr. Bigot, and on speaking about that interview, he repeatedly confirmed that he could not remember, and that various comments were open to interpretation. He's confirmed that Ms. Cross presented no reasons why he should not apply for his role with the company, and yet Ms. Cross has confirmed to us today that Mr. Bigot has a tendency to only recruit people who are like him. By virtue of the arguments that they have both presented today, they seem to draw a very great distinction between their two characters, Mr. Bigot being a devout Christian and Mr. Burnish being a homosexual. The consistency is also found to be flawed in Mr. Burnish's recollection of what information that he was told by Ms. Cross when he questioned her about the reasons he was not offered the job. On that basis, I would invite the tribunal to find the respondent's evidence on the issue preferable to that of the claimant's.
Mr. Deere, we've got that point, and you've made it very, very well. Can you help us on the victimisation point? Because what the claimant says is that your client, Mr. Bigot, deliberately telephoned his current employer as an act of revenge, and he made life difficult for the claimant. Now, just help the tribunal. What do you say about that, Mr. Deere?
Well, again, we've heard from Mr. Biggett on that particular issue today, and he confirmed that if he were faced with a similar situation and told that his star employee was applying for a job with either a competitor or another firm, that he would take every step available to him to keep that employee. On that logic, he could not have assumed that Mr. Burnish's current employer would then subject him to any penalty. Indeed, Mr. Biggett has informed the tribunal that he contacted the claimant's current employer on receiving notice of the claim in order to establish the veracity of certain claims that had been made. Mr. Biggett states that he was incensed at the allegation against his personal character, that he made a judgment based on an applicant's sexual orientation. On receiving the actual claim itself, he sought to try and establish the factual accuracy of claims that had been made that may then be relevant to the proceedings. As stated previously, we have not had notice of this claim, and therefore the details that we were required to establish its success or failure. We've heard no evidence as to the actual nature of the conversation that took place between Mr. Biggett and Mr. Burnish's employer, nor have we heard any evidence as to the reason why Mr. Burnish's employer then decided not to offer him a pay rise. Indeed, and in contrast to that, all we have is a letter from Mr. Burnish's employer which states that they are under no obligation to offer him a pay rise.
Mr. Deere, you're nearing your 10 minutes. As a final point, can you just address the tribunal on the reasonable steps defence issue? I think we clarified at the outset that the first respondent is basically saying that they are not responsible, they're not liable for any discrimination because the second respondent has been on various training courses. Can you just help me and give me your best submissions on that, please?
Indeed, thank you, sir. Well, as we have previously pointed, and both witnesses have confirmed today, the company ensures that all employees attend regular training courses on equal opportunities and diversity and what is appropriate within the workplace. The company has also taken a reasonable step to ask a senior director of 20 years' experience to engage in a recruitment process. Now, it has been said by Ms. Cross and Mr. Biggett, well, Mr. Biggett has confirmed, that he always gets this process correct. He's faced no previous allegations of this nature. Ms. Cross indeed confirmed that as well, and said that no complaints had been made and that she had no reason to raise concerns with Mr. Burnish. It therefore seems unlikely in the respondent's submission that Mr. Biggett should, on perhaps a bad day, suddenly take exception to this one individual applicant's sexuality, even if he did know and was aware of that sexuality at the time of the interview. And therefore it's first respondent's submission, my apologies, sir, that if by some aberration that were to be the case, or the tribunal were to find that to be the case, then the responsibility for that action would rest solely with the second respondent.
Okay, thank you, Mr. Deere. Mr. Ross, if we could have your submissions, please.
Yes, sir, thank you. I'm grateful for Mr. Deere's concession on the early conciliation point, so I'll address the application to amend the claim to include victimisation. So, the tribunal has been provided with the law on this, the cases of Cocking and Sandhurst and Salcombe Bus. Essentially, what the tribunal is asked to consider is whether or not there will be any injustice or hardship which may be caused to the parties. Mr. Deere has made the point today that the respondent was prevented from providing evidence in relation to a victimisation claim. Yet we have heard evidence clearly from Mr. Bigot on this particular point. The respondent was aware of the nature of the claim and could have called any additional witnesses that it wished to do so. The claimant is seeking to make the application to amend because there is an incident that has occurred on the 30th of August after the date of the initial claim being submitted. And the Tribunal has made it quite clear that where it's possible, it is desirable for there to not be multiple claims going through the system. Also, any additional claim that the claimant should choose to make would still be in time should it be issued today. But for obvious reasons, it would be a waste of judicial time, cost and money to submit a new claim and hear a claim on similar facts presented today. On that basis, we would suggest that there is no injustice or hardship to the respondent, and such an application should be permitted on the part of the claimant. If the Tribunal is with me on that, Mr. Deere has addressed the question of whether or not the law actually protects the claimant in these circumstances. The Tribunal has been presented with the case of Jessamine and Rostock, and is also familiar with Section 39 of the Equality Act. Section 39 of the Equality Act specifically sets out that an applicant should not be victimised against, but it sets out specific circumstances in which that applies. It is accepted that post-termination victimisation does not appear in that list. However, in line with the authority of Jessamine and Rostock, we would suggest that the same drafting error has been made in the circumstances, and therefore it can only be right that a claim of post-termination victimisation should also be designed to protect job applicants as well as workers. In relation to the main claim of direct discrimination, we've heard evidence from Mr. Bigot, Mrs. Miles and the claimant. The claimant, albeit clearly very nervous, has provided an honest account of events and a reliable one, whereas the evidence of Mr. Bigot and Mrs. Miles was inconsistent on numerous occasions. In particular, Mr. Bigot's evidence in relation to the reasons for the rejection of the claimant from the role. In his witness statement, he set out that it was due to his experience, yet he has conceded today that his experience was absolutely fine. Mr. Bigot is a devout Christian, but by his own admission does not approve of homosexuality. However, as the Tribunal is aware, in relation to the case of London Borough of Islington and Liddell, his beliefs do not allow him to discriminate against somebody because of their sexual orientation. And Mr. Bigot was at great pains to tell us today just quite how much of an expert in relation to discrimination he is.
Yes, we remember that, Mr. Ross.
When the claimant was interviewed by Sarah Miles, she had no doubts that he was an excellent candidate, nor did she have any doubts as to his experience. Mr. Bigot alleged that it was in relation to that, but as we've heard today, that's clearly not the case. Mr. Bigot also lied to Sarah Miles about the reason for rejecting the claimant. We have heard from Ms. Miles today that he initially told Ms. Miles that was due to the fact that the claimant rejected the role. It's clear from the comments, in particular made by Mrs. Cross, that Mr. Bigot did notice that the claimant was wearing a gay pride bracelet. The claimant pointed out that this was rainbow in colour and had distinctive bold black font, and it would have been readily identifiable. Mr. Deere made the point of presenting a bracelet today that was embossed and could not be easily read. Across a small table, this would have been readily identifiable to Mr. Bigot. Mr. Bigot immediately went downstairs and explained that he should have been told that the claimant was gay and couldn't have a gay employee working in the business, as he wouldn't fit in. Despite his protestations, private life clearly did matter to Mr. Bigot, and he was more interested in the sexuality of the claimant and whether he had a girlfriend. Particularly in light of the evidence of Mrs. Cross, the Tribunal was asked to find that the respondent chose not to employ the claimant because he was gay, which was contrary to section 13 and 39 of the Equality Act, and that claim should succeed.
And Mr. Ross, if you could address the tribunal very briefly on the substance of the victimisation complaint.
Of course, sir. By Mr. Biggett's own admission, he only chose to call the claimant's current employer when he became aware that the claimant was bringing proceedings under the Equality Act against the respondent and himself. He alleges that he did this because he did not believe the claimant had been honest about his experience, but we've heard today that that is simply not the case. Also in cross-examination, Mr. Biggett clearly understood that this would frustrate, annoy and cause issues for the claimant at his current workplace. Not only would it cause those issues, but we've heard from the claimant that he, as a direct result of the call, he was not given a £3,000 pay increase that he had been promised. It's clear that the actions of Mr. Biggett were deliberate and calculated and intended to cause a direct detriment to the claimant. The claimant has made a protected act by bringing these proceedings, and the detriment suffered is as I've explained to the tribunal today.
That's clear, Mr. Ross. Could you finally address this on the reasonable steps defence? I think I highlighted at the beginning the first respondent seeks to wash its hands, as it were, of any potential liability because they say they've provided training courses, etc., and therefore the second respondent should be solely liable. What do you say about that?
We've been provided with no evidence of any discrimination policy or any handbook before the tribunal today. Simply issuing training to certain employees and not following up on matters is not sufficient for the first respondent to discharge that burden, and we would suggest in the circumstances that it has failed to do so, and any award should be made jointly and separately. So there is one further point, if I may, in relation to aggravated damages. As the tribunal is aware, if a respondent misconducts himself in the defence of a discrimination case, and the misconduct is of sufficient gravity where the tribunal feels it's appropriate that there's been an aggravating and material effect on the victim, a tribunal is entitled to award aggravated damages against the respondent in the circumstances. If the tribunal is not with me in relation to the victimisation claim, we would submit that the tribunal should be with me in relation to an aggravated damages claim for the actions of Mr. Biggett. Again, we would look to directly suggest that there has been a significant impact on the claimant as a result of the behaviour of Mr. Biggett. And we have heard today that the claimant has had to undergo counselling and therapy in relation to this at his own expense.
Mr. Ross, does that conclude your submission?
Yes, sir, it does.
Thank you very much. Now, if you just give, the members and I have already had an opportunity over the break to discuss this matter. If I just quickly confer, hopefully we should be able to give our judgment very, very shortly. We've carefully and thoroughly considered all of the evidence and the very helpful submissions, and I'm pleased to say that we have reached a unanimous decision. I'm going to read my judgment. You will, of course, be receiving a full copy in the post that will be sent to you. Therefore, I'm not going to go into any detail on the law. I'm just going to concentrate on the introduction and the findings. The claimant was represented by Mr. Barry Ross, solicitor, and the respondent was represented by Mr. Deere, solicitor. The claimant gave evidence on his own behalf. The respondents called two witnesses, Mr. John Biggett, commercial director with 20 years experience, and Mrs. Sarah Miles, sales director of the first respondent. The tribunal also heard evidence from Mrs. Charlie Cross, who attended pursuant to a witness order. There was an agreed bundle of documents, and some further documents were added during the course of the hearing. I was also provided with written closing submissions by both representatives. Just want to highlight the issues, and then we will go into our findings. As a preliminary issue, the Tribunal had to consider whether it had jurisdiction in order to consider the claimant's claims. This depends on whether he has properly complied with the ACAS early conciliation regime. The claimant brings claims of direct discrimination based on sexual orientation and victimisation against the respondent. The claimant is homosexual and identifies himself as a gay male, which is a terminology that we shall use throughout this judgment. The claim of direct discrimination relates to the claimant's allegation that he was not offered the role of customer services manager with the first respondent because of his sexual orientation. The Tribunal will need to decide on what was the real reason for that. The claim is brought against both the first and second respondent. The second respondent, Mr. Biggott, is the commercial director. He interviewed the claimant and it was his decision not to offer the role to the claimant. Accordingly, the claimant alleges that Mr. Biggott is liable, and with the first respondent they are jointly and severally liable. The first respondent pleaded the reasonable steps defence, as it is colloquially known amongst lawyers. The Tribunal therefore had to consider whether the first respondent had taken all reasonable steps with regard to training on equal opportunities. The claimant's claim of victimisation is based on the allegation that the second respondent, Mr. Biggott, after these proceedings had been instigated, had telephoned his employer, causing him to lose a pay rise and causing difficulties in the working relationship with his employer. I now turn to the Tribunal's findings of fact. The first respondent is engaged in the business of industrial cleaning, operating from a prime location in the centre of Abingdon. The second respondent, Mr. Biggott, is the first respondent's commercial director. He has held, and he will be pleased to hear this, 20 years experience. He is a married man with 3 children, and he is a devoted Christian. Sarah Miles is the first respondent sales director and has held that position for 5 years. The claimant, Mr. Gideon Burnish, describes his sexual orientation as gay. The claimant is 34 years old and he has worked in customer service ever since leaving school, working his way up from customer service to customer service manager in his current job. Having seen the role of customer service manager advertised with the first respondent, the claimant applied to the recruiters and made sure that he tailored his CV to the role. We find that he was eminently qualified for the role. On the day of the interview, he made sure that he was well prepared, appropriately dressed, and in a positive frame of mind. He was first interviewed by Sarah Miles, the sales director, and unsurprisingly, she was very impressed with him and she thought that he would be an excellent candidate. Under cross-examination, Sarah Miles sought to resile from some of that evidence and suggested that the word excellent was open to debate and interpretation. We don't accept that. We accept she thought he was an excellent candidate and perfectly suitable for the role. The claimant came back for a second interview, and it was at this stage that things took a turn for the worse. This time he was interviewed by the second respondent, Mr. Biggott, who we find took a dislike and had a disdain of the claimant from the outset. We very carefully listened to the evidence from the claimant, and we accept and we were impressed with his evidence when he said that he just had the feeling and he knew it was obvious that the second respondent did not like him. We find that the claimant, that Mr. Biggott had seen the gay pride wristband that the claimant was wearing, and that this was enough to stimulate Mr. Biggott's prurient interest in the claimant's personal life and in his sexual orientation. We found that the claimant provided a clear description of the bracelet, and despite Mr. Deer's attempt at undermining the claimant's evidence, we accept what the claimant said on this point. We accept that the claimant's evidence, Mr. Bigot asked him on a number of occasions wholly inappropriate and irrelevant questions about his personal life, and repeatedly asked him if he had a girlfriend. We should pause to say at this point that we found the claimant's narration of events, and we take into account that he was understandably nervous, but we found him to be a consistent and a reliable witness. We thought that he was honest and he was credible. Where there was any conflict between the claimant's evidence and the second respondent's evidence, we preferred the claimant's evidence. We should also say at this point, dealing with the issue of credibility, that we were not impressed with the second respondent's evidence. We thought that he had all the hallmarks of a witness who was not telling the truth. He was not a reliable historian of the truth, and we reject his evidence where it conflicts with the claimant's. His evidence was inconsistent, it was contradictory, and it was not reliable. Mr. Bigot made his disdain of the claimant clear. He then wasted no time in informing the recruitment agency that the claimant was not suitable. We have no doubt that the reason he turned the claimant down for the job was because of the claimant's sexual orientation, and that he believed the claimant was gay, that the claimant would not fit in to the environment, and for this reason alone, he did not wish to employ him. We should also pause at this point to comment on the evidence, the important evidence we heard from Mrs. Charlie Cross. We were again very impressed with Mrs. Cross's evidence. We were conscious of the fact that she did not want to come to this tribunal. She was witness ordered to come to this tribunal. She was understandably fearful of losing her job. She gave her evidence in a plausible manner. When questions were put to her, she did not hesitate with her response. She answered truthfully, and she told the tribunal very clearly that Mr. Bigot suspected, or he knew, that the claimant was gay, and that this was the reason he was not given the job, and we accept that evidence. Having sought to mislead Mrs. Miles, once the claimant's ET1 had landed on Mr. Bigot's desk, we find that he was enraged that the claimant had brought a tribunal claim against him and the company, and we find that he decided to telephone the claimant's employer in an act of revenge or retaliation in order to make life difficult for the claimant. We reject his evidence that he was sceptical about the claimant's experience. We don't find that there was any basis to that whatsoever. We have heard nothing in evidence that would cause us to doubt the claimant's experience. We find that having turned the claimant down, another candidate was offered the role of customer services manager, whom Mr. Bigot has described proudly as being married with children. Again, if there were any doubt in our minds as to the reason the claimant was turned down for the role, that was dispelled by Mr. Bigot's own evidence. However, we accept the first respondent's evidence that the role was made redundant after 5 months. We also accept the first respondent's evidence that equal opportunities is taken seriously by the first respondent, albeit not by Mr. Bigot. And we find that the company regularly provided training courses on equal opportunities, and the company did as much as it reasonably could do to train its employees on what was expected and what was not expected in the workplace. It is simply unfortunate that the second respondent did not heed the training, but the first respondent did, as we've said, as much as it could. Therefore, briefly, we wish to outline our conclusions. As far as the early conciliation jurisdiction is concerned, that point has been conceded very helpfully and sensibly by Mr. Keir. Direct discrimination, it is clear from the Tribunal's findings that we uphold the claimant's claim on this ground, and we find that he has been discriminated against contrary to the Equality Act 2010. However, as stated, we accept Mr. Deer's submissions on the reasonable steps defence. Whilst the Tribunal grappled, it must be said, with this point, it was persuaded by the fact that the second respondent did carry out equal opportunities training, and we feel that it does demonstrate a genuine commitment by the first respondent on equal opportunities. What our findings mean, however, is that whilst the first respondent will not be held liable for the discrimination, it does mean that the second respondent is liable. Victimisation. There's an application to amend to include a claim of victimisation, and we've considered the case law very carefully. We've balanced the interests of justice, and the Tribunal's decision is to allow the application. We feel that the injustice that would be caused to the claimant by not allowing the claim to be brought outweighs any potential injustice that would be caused to the respondent. As far as whether or not the law covers victimisation, we find that it does. We simply cannot accept that the Equality Act does not provide protection for victimisation in these circumstances. And if we were wrong on that, the Tribunal is willing to adopt what's called a purposive interpretation. We are willing to interpret the Equality Act in order to give effect to European law. We are still members of the European Union. We are still influenced by its decisions, and the European Union has made it clear that victimisation is something that should be protected, and therefore that is our decision. As far as the merits of the victimisation is concerned, again, we find that the claimant was victimised by the second respondent. At this juncture, we stop to consider whether Mr. Bigot's conduct should lead to an award of aggravated damages as pressed upon us by Mr. Ross. We find that it should. We find that Mr. Bigot's conduct, his misconduct, was of sufficient gravity that it should be compensated for by the Tribunal. We also find that by contacting the claimant's current employer, he knew or he suspected that it might cause difficulties for the claimant. It's fortunate that the claimant did not lose his job. We find that Mr. Bigot's conduct was high-handed, malicious and oppressive, and accordingly an award of aggravated damages should follow. Another point that troubled the members and I, and we take an extremely dim view of the way in which the litigation has been conducted by the respondents, in particular Mr. Bigot. And we note here, for example, that in the respondent's response, in its ET3, in the ET3, the respondents said this: savers were accepted. The respondents deny all claims made by the claimant, which they say are vexatious and made without reasonable prospect of success. We find that that was in an attempt to intimidate the claimant. It was untrue and it was wholly inappropriate. Turning to remedy, again, the details, Mr. Ross and Mr. Deere, will be set out in my judgment, but the tribunal makes the following award. We bear in mind the measure of loss is tortious. In other words, a complainant must be put in, so far as possible, the position that he would have been in had the act of discrimination not occurred. And we finally remind ourselves that any award must be just and equitable. Injury to feelings, we award £7,000. This is in the lower bracket of the updated Vento guidelines. Whilst this was a one-off act of discrimination, we're conscious of the impact that it had on the claimant, and we accept that he has had a series of counselling sessions to help him come to terms with the sense of rejection, injustice and hurt that he told us he felt. Aggravated damages, we award £3,000. We accept that there is some overlap with the award of injury to feelings, but we recognise that an award is appropriate to reflect the additional injury to feelings resulting from Mr. Biggott's high-handed and malicious conduct. Victimisation, we award £3,000. We find that the claimant would have received a pay rise of £3,000, but for Mr. Biggott's telephone call. Now, on the issue of loss of earnings, we have awarded £5,000. We find that the net difference between the claimant's current salary and what he would have received had he been appointed to the role is £1,000 per month. And we've taken into account the value of any lost benefits to the claimant. However, we accept the respondent's evidence that the role was made redundant after 5 months and that it has not been replaced. Accordingly, we find that the claimant would have been made redundant after 5 months, and that is why we have restricted his compensation to 5 months. We have also awarded the cost, the tribunal fee of £1,200, and we've taken into account the 5 counselling sessions at £150 each. That gives a total award of £19,950. Interest at 6% will also have to be added to that. Gentlemen, thank you very much. The tribunal is grateful to you for the way in which you presented the case and for your very helpful submissions. That concludes the case.
Thank you, sir.
Well, sorry, I should have put my jacket back on. I'm sorry to keep you a little bit longer, but as always happens in employment tribunals, sometimes these things just take a little bit longer than anyone anticipated. Luckily, on this occasion, it was 20 minutes, not 4 days, as we've sometimes found. I would like to take this opportunity of thanking in particular our witnesses who have been immense sports. Eros, Ben and Catherine, thank you so much for taking part. I think they deserve a round of applause. Owen, this is their day job, but they were grateful to have the opportunity to do this in front of you. And finally, to our fantastic panel, a big round of applause, please, for Jill, for Kevin and for Nick. And Kevin will be following, obviously, Judge Rinder next, and also on Strictly Come Dancing next season. So anyway, thank you.